Imagine a life carefully pieced together, thread by fragile thread. Each strand represents a day of work, a child's school enrollment, a new friendship formed in an unfamiliar land. For 500,000 souls from Cuba, Haiti, Nicaragua, and Venezuela, this was their reality in America. They had sought refuge, offered a sliver of hope under the CHNV humanitarian parole program. They were building new lives, contributing to communities, daring to dream of stability. This was not a clandestine existence. They had come through legal channels, trusting a system that promised temporary safety. Then, with the swiftness of a guillotine's descent, the thread was threatened. The Supreme Court's decision on May 29, 2025, sent a shockwave through these communities. The news spread like wildfire, igniting fear and despair. The very foundation of their tentative security crumbled. What was once a promise of sanctuary now felt like a cruel mirage. The highest court in the land had spoken, and its words signaled not protection, but peril. The stability they had painstakingly constructed was now on the verge of collapse, leaving them suspended over an abyss of uncertainty and potential deportation back to the very dangers they had escaped. The suddenness of the ruling was a brutal blow. The Supreme Court's decision was stark. On May 29, 2025, the conservative majority took action. They granted an emergency application from the Trump administration. This was not a minor procedural tweak. This was a seismic shift. The court effectively stayed a lower court injunction. That injunction had been a shield. It had protected the Biden-era CHNV humanitarian parole protections. With the Supreme Court's intervention, that shield was lowered. The path was cleared for the administration to revoke these vital protections, leaving hundreds of thousands in a terrifying limbo, their futures hanging precariously in the balance. The immediate impact was devastatingly clear. Over 500,000 migrants, hailing from Cuba, Haiti, Nicaragua, and Venezuela, faced a grim new reality. Their work authorizations, the very means by which they supported their families and contributed to the economy, were suddenly at risk. Their protection from deportation, the core promise of the parole program, was stripped away. All this, while the underlying legal battles over the program's termination remained unresolved. They were caught in a legal crossfire, their lives collateral damage in a high-stakes political and judicial confrontation. In the face of this stark judicial pronouncement, a powerful voice of dissent emerged. Justice Ketanji Brown Jackson, joined by Justice Sonia Sotomayor, offered a scathing critique. Her words were not couched in arcane legalisms. They were a direct and passionate defense of human dignity and due process. Justice Jackson argued that the majority's decision fundamentally misread the scales of justice. It prioritized an abstract notion of governmental power over the tangible, devastating impact on human lives. She saw the ruling as a failure to uphold the most basic principles of fairness and equity when individual lives hang so delicately in the balance. Justice Jackson's dissent zeroed in on the concept of irreparable harm. The government argued it would suffer such harm if it couldn't immediately enforce its immigration policy changes. The Trump administration, naturally, presented a different narrative. They defended the revocation of the CHNV parole protections as a necessary measure, rooted firmly in the national interest. Their arguments centered on the assertion of executive authority in immigration matters. They contended that the lower court's injunction, which had temporarily preserved the parole program, unduly constrained the president's power to manage the nation's borders and immigration policies. This was, in their view, a fundamental issue of sovereignty, and the executive branch's prerogative to act decisively in what it deems to be the country's best interests. Furthermore, the administration claimed that allowing these parolees to remain in the United States created irreparable harm to the government itself. This harm, they argued, manifested in an undermined foreign policy and a compromised ability to effectively manage the overall immigration system. The presence of these 500,000 individuals, who had arrived under a program the current administration sought to dismantle, was portrayed as an obstacle to implementing their preferred immigration strategy. The argument was essentially that the orderly enforcement of immigration law superseded the individual circumstances of those affected by the policy reversal, regardless of prior assurances. The Supreme Court's ruling is not an abstract legal debate. It is a decree with devastating real-world consequences. For the over 500,000 migrants from Cuba, Haiti, Nicaragua, and Venezuela, this decision transforms their lives into a harrowing state of limbo. Many have resided in the United States for months, some for years, under the CHNV parole program. They have diligently followed the rules, obtained work authorizations, and woven themselves into the fabric of their local communities. They are neighbors, colleagues, parents of American-born children, and contributors to local economies, paying taxes and filling essential jobs. Now, these established lives are thrown into utter chaos. The threat of deportation is no longer a distant fear, but an imminent possibility. Families face the agonizing prospect of separation, with parents potentially torn from their children, spouses from each other. The Supreme Court's decision to allow the Trump administration to revoke CHNV parole protections reverberates far beyond the immediate plight of the 500,000 affected migrants. It raises profound questions about the stability of humanitarian protections and the very nature of due process in the American legal system. This ruling starkly underscores the fragile and often precarious status of temporary safeguards offered to vulnerable populations. What was granted by one administration can be swiftly and seemingly arbitrarily rescinded by another, leaving individuals who relied on those promises in a desperate and untenable position. Legal experts have voiced significant concern, warning that this ruling may signal a disturbing trend. There appears to be a growing deference by the conservative-leaning court to executive power, particularly in immigration cases decided on the emergency docket. The Supreme Court's ruling on the CHNV parole program is more than a legal decision. It is a moment of national reckoning. It forces us to confront uncomfortable questions about who we are as a nation and what values we truly uphold. Are we a country that extends a hand to those fleeing persecution and violence, or one that slams the door shut when political winds shift? Justice Jackson's dissent serves as a powerful moral compass, urging a path that prioritizes human dignity and due process over unchecked governmental power and administrative convenience. Her words challenge us to look beyond legal formalisms to the real people whose lives are at stake. This decision plunges over 500,000 individuals into a humanitarian crisis of our own making. These are not abstract numbers. They are families, workers, and community members who sought refuge and played by the rules. To now cast them into the terrifying uncertainty of potential deportation is an act that demands profound ethical reflection. If you believe in standing up for the values of fairness and compassion, don't stay silent. Share this video, engage in the conversation, and reach out to your representatives to make your voice heard. Together we can push for policies that reflect the best of who we are. Thank you for watching, and let's keep the dialogue going.